Good evening and welcome to the Centre for Comparative Constitutional Studies Global Seminar Series, where this evening we are honouring the legacy of Sir Gerard Brennan to Australian public law. My name is Kristen Rundle. I'm a professor here at the Melbourne Law School, and I'd like to begin our evening by acknowledging that I'm hosting this webinar on the lands of the Wurundjeri people of the Kulin Nation. I pay my respects to their elders past, present and emerging. And I also acknowledge any Indigenous persons joining us this evening, as well as the Indigenous leadership at this university. Sir Gerard Brennan, AC, KBE, QC, passed away on the 1st of June this year, aged 94. He is known above all as a Justice of the High Court of Australia from 12 February 1981 to 20 April 1995, and as its Chief Justice from 21 April 1995 to 21 May 1998. Our speakers this evening will be providing much more by way of detail of Sir Gerard's innumerable contributions to the Australian legal system and to Australian public law in particular. As a teacher of administrative law, however, I can't allow my time as your chair this evening to pass without paying my own respects to Sir Gerard. It is simply too mild a statement to say that Sir Gerard, whether as Brennan P or Brennan J or Brennan CJ, had a profound influence on the development of a modern administrative law. In more ways than one, he was its architect, and it is difficult to imagine that his contribution could or will ever be equalled. We're deeply fortunate this evening to have two people with us who are especially well positioned to speak to Sir Gerard's legacy. Our first speaker is Justice Stephen Gageler, AC of the High Court of Australia. Admitted as a barrister of the Supreme Court of New South Wales in 1989 and appointed senior counsel in the year 2000, in his pre-judicial life, Justice Gageler practiced extensively throughout Australia, principally in constitutional law, administrative law and commercial law. He was appointed Solicitor General of Australia in 2008 and was serving in that role at the time of his appointment to the High Court in October of 2012. Justice Gageler, welcome. You have the floor. Thank you.
Thank you, Professor Rundle. I am pleased to be joining you from the High Court building in Canberra, where Sir Gerard spent a great deal of his professional life. And it gives me great pleasure to be part of this seminar this evening. Sir Gerard was a good friend to me when I joined the High Court, and he became something of a mentor. I am personally very much indebted to him. The great Sir Maurice Byers was very much a contemporary of Sir Gerard Brennan. He once said that law is an expression of the entire personality. For those who have immersed themselves for a professional lifetime in the administration of the law, that is true. To them, law is not easily compartmentalized, and who they are cannot readily be separated from what they do. Of judges trained within the system of judicial functioning, Sir Gerard Brennan himself said that their minds are cast in the mould of the system. They develop personal qualities which are compatible with the system, and that they both determine and are formed by the functions which they discharge. Their personalities will have been shaped by their professional experiences and by the legacies of judges who have gone before them. Their own legacies will inevitably be expressions of their own personalities as so shaped. So examining the legacy of Sir Gerard Brennan to Australian law, or to so much of it as might be classified as public law, I start unapologetically with a reflection on the personality of Sir Gerard Brennan. Nowhere is that personality better depicted than in the official portrait of him as Chief Justice of the High Court. I hope you can see it prominently on your screens at the moment. The portrait hangs downstairs from where I'm now sitting in courtroom number 3 of the High Court building here in Canberra. It hangs there in a line of succession with portraits of past Chief Justices who worked in this building before him and after him, beginning with Sir Garfield Barwick and currently ending with Robert French. The painting was painted by Robert Hannaford in 1996. That was during the first of Sir Gerard's 3 years as Chief Justice. What you see in the portrait is a man aged 67 years. He is in evident good health and good humour. He is seated casually. Tellingly, in his casualness, he is still dressed in judicial robes. He's evidently comfortable occupying the ultimate office to which he has just been appointed. For that office, he is impeccably qualified. He's been a judge for 2 decades, most recently a Justice of the High Court, and before that, an inaugural member of the Federal Court. Overlapping with his time on the Federal Court, he's been President, indeed the first President, of the Administrative Appeals Tribunal. Before that, he's been a barrister for a quarter of a century. A decade of that he has spent as senior counsel. He looks directly and calmly at the viewer. The light falling from behind and to his right highlights his face in repose. There is a glint in his glasses, or is it a twinkle in his eye? His demeanour is one of composure. Some might describe it as tranquility. He exudes a wisdom which surpasses mere accumulation of knowledge. He exudes intellectual humility, born of life experience. He exudes compassion. Now, held in his 2 hands and resting lightly on one knee is a copy of what is evidently volume 175 of the Commonwealth Law Reports. I happen to have a copy of the same volume here with me. The volume covers the period 1991 to 1992. It includes the report of the judgment in Mabo, which commences right at the beginning of the volume. You'll see, if you look carefully at the portrait, that inserted into the volume is a bookmark. Exactly what is marked by the bookmark is not entirely clear. It might well be a passage in his own celebrated reasons for judgment in Mabo as a pivotal member of the majority. It might equally be the commencement of the report of the decision in Marion's case. Marion's case was decided a month before Mabo and is reported immediately after Mabo in that volume. It is a case in which Sir Gerard delivered not a majority judgment, but a powerful dissent. In an interview he was to give after his retirement as Chief Justice, as part of the National Library's Oral History Project, he described it as the hardest judgment he had ever written. Marion's case and Mabo might or might not qualify as public law. That very much depends on the taxonomy that is adopted. Whatever the way the category of public law might be defined within any given taxonomy, Sir Gerard Brennan's enduring contribution to the category of public law can only be fully appreciated taking account of his reasons for judgment in both of those 2 cases. Together, they manifest the deep humanity which was at the heart of who he was, and which in turn was central to the entirety of his legal philosophy and his judicial technique. Famously on display in Sir Gerard's reasons for judgment in Mabo was his embracing of moral responsibility for what he described as the organic development of legal doctrine in order to accord with contemporary notions of justice and human rights, whilst respecting and maintaining what he described as the skeleton of legal principle, which gives the body of our law its shape and internal consistency. In Mabo, he exercised that moral responsibility with unsurpassed technical skill. He did so to reappraise feudal notions of land tenure and to restate the common law of Australia with reference to land title. He did so for the express purpose of redressing an historic injustice by which the rights and interests of Australia's Indigenous inhabitants had been treated as non-existent. Spelt out in Marion's case was a fundamental animating consideration, which can be seen to have informed the moral choice starkly made in Mabo and to have pervaded Sir Gerard's jurisprudence more generally. The central question in Marion's case was as to the power of another, be that other a parent or a guardian or a court, to authorise the sterilisation of an intellectually impaired child. The majority view was that a court had power to authorise sterilisation by reference to the criterion expressed as the best interests of the child. Sir Gerard disagreed. Absent community consensus on the ethical principles to be applied, the best interests approach appeared to him to depend so much on the value system of the decision maker as to give rise to an unexaminable discretion in the repository of the power. The best interests approach for that reason provided an insubstantial protection of human dignity. Human dignity, he explained, to be a value common to our municipal law and to international instruments relating to human rights, which required that the whole personality be respected and which was required to be afforded equally to all. Sir Gerard's namesake and one-time associate, Gerard Carney, has pointed out that a concern for human dignity equally afforded to all was at the core of Sir Gerard's approach to the judicial administration of the whole of the law. In a lecture he gave at Bond University, I suspect at Gerard Carney's invitation, shortly after his retirement from the High Court, Sir Gerard Brennan took on the Herculean task of mapping out the respective roles and immunities of the Parliament, the Executive and the courts under the Australian Constitution. True to that core concern, he commenced not with reference to the constitutional structure or the constitutional text or to constitutional history. He commenced instead with the observation that constitutions are made for a people and a time. Inevitably, times will change, he said, but humankind will remain the same, with the same mystical spark that gives each a unique dignity and, as those who believe would hold, an eternal destiny, with the same basic concern for life, liberty, property, and human relationships that can be satisfied only in a society governed by law. Essential to the preservation of human dignity in a society governed by law, as Sir Gerard saw it, was the imposition of legal limits on the capacity of any one person or body of persons to exercise power to affect the interests of any other person. The unique and essential function of courts in such a society, as he saw it, was to declare and enforce those legal limits on power. Indispensable to the capacity of courts to perform that unique and essential function was the maintenance of public confidence in those courts as faithful guardians and neutral arbiters of disputes about those legal limits on power. And indispensable to the maintenance of that public confidence was the appearance, and much more than that, the actuality of competence, fairness, and impartiality on the part of the judiciary. With customary elegance, Sir Gerard explained that the rule of law depends on and is perhaps synonymous with confidence in the courts, that it must rest on the common acceptance by all who are subject to the jurisdiction of the courts of the authority of the courts to determine cases and controversies, and that to destroy public confidence in the courts is to destroy the foundation of the rule of law. He said that, and I quote, "Public confidence depends on the reality and the perception of a judiciary that is competent, of unshakable integrity, and isolated from influences that might improperly affect the administration of justice according to law. Its awesome powers must be exercised always in the service of others. It must always respond to any application duly made to it, and it must account publicly and to the parties for the reasons for its decision. It is a judiciary for a society living under the rule of law. Its standards must be and be seen to be unimpeachable." Practicing always what he preached, Sir Gerard throughout his judicial career personified those essential judicial attributes. Judicial review is a topic that must lie within the heartland of public law on any taxonomy. Sir Gerard's enduring contribution to our collective understanding of judicial review followed directly from that broader conception of the essentiality of the judicial function to the preservation of human dignity in a society living under the rule of law. Judicial review of administrative action, he told us, is neither more nor less than the enforcement of the rule of law over executive action. It is the means by which executive action is prevented from exceeding the powers and functions assigned to the executive by law, and the interests of individuals are protected accordingly. Moreover, he told us, there is an essential unity in the role of a court engaged in judicial review of administrative action and the role of a court engaged in judicial review of legislative action. In each case, as he famously put it in Quinn, in language destined to become canonical, the essential warrant for judicial intervention is the declaration and enforcing of the law affecting the extent and exercise of power, and the duty and jurisdiction of the court do not go beyond the declaration and enforcing of the law, which determines the limits and governs the exercise of the relevant power. With those words, he articulated a pure conception of judicial review, untied to the jurisdictional powers of any particular court, uncomplicated by obscure nomenclature, and uncluttered by notions of grounds of review or concerns about the availability of particular judicial remedies. In its simplicity lay its strength. By strictly confining a court engaged in judicial review to the declaration and enforcement of the law, it ensured that the judiciary remained within its peculiar field of institutional competence. In so doing, it enhanced the public confidence in the judiciary, on which the continuing ability of courts to engage in judicial review for the benefit of the individual ultimately depended. In due course, that pure conception would come to inform our collective understanding of the express constitutionally entrenched jurisdiction of the High Court to engage in judicial review of the exercise of power by Commonwealth executive and judicial officers, as well as our understanding of the implied constitutionally entrenched jurisdiction of state supreme courts to engage in judicial review of the exercise of power by state executive and judicial officers. As to the judicial discernment of the content of the law, which determines the limits and governs the exercise of power, Sir Gerard saw plenty of scope for the Australian Constitution to be interpreted so as to keep pace with long-term changes in Australian society, just as he saw plenty of scope for common law principles of statutory interpretation to be developed to ensure that the exercise of powers conferred by statute kept pace with contemporary conceptions of justice. What he insisted upon was that any constitutional implication be firmly anchored in the text and structure of the Constitution, and that any principle of law to be judicially developed be capable of being stated with precision and preferably in the form of a syllogism. As Sir Anthony Mason said of him in explaining his contribution to judicial review in a paper given at a conference held at the Australian National University in Sir Gerard's honour, celebrating his contribution to administrative law very soon after his retirement, rule-based rather than discretionary justice was central to Sir Gerard's jurisprudence. I had the opportunity to comment on Sir Anthony's paper at that conference. I remarked that an analysis by Sir Anthony of the contribution of Sir Gerard to administrative law was like an analysis by Picasso of the contribution of Matisse to modern art. Sir Gerard, I recall, was not especially pleased with that analogy. He saw himself as a Rembrandt or a Vermeer. Over 20 years later, I am still convinced that he was wrong and I was right. Rembrandt and Vermeer were masters of an earlier age. Sir Gerard, like Matisse, was a master of the modern age, and he, like Matisse, had a distinctive style characterized by distinct forms and harmonious composition. More than once in his extracurricular writings, Sir Gerard referred to Learned Hand's posthumous tribute to Benjamin Cardozo, published in the Harvard Law Review in 1939. Hand referred to the customary law of English-speaking peoples as a structure made by the hands of generations of judges, each professing to be a pupil, yet each in fact a builder who has contributed his few bricks and his little water, often indeed under the illusion that he has added nothing. Sir Gerard Brennan was a judge who should not have been under any such illusion. To the question of what he added to Australian public law, the answer can be given with precision in a way which I believe would have pleased him. I give that answer now. He added its essential unity, he added its guiding principle, and more than that, he added its moral compass. Thank you.
Thank you sincerely, Justice Gageler, for those wonderful reflections that have enriched all of our understandings of Sir Gerard as the man and as the judge, and to do so through keeping the frame of art in view was especially moving and especially welcome. So thank you very much for your efforts tonight. I'm now going to introduce our second speaker for this evening, Christopher Horan QC from List G Chambers in Melbourne. Admitted to the Victorian Bar in 2000, Chris Horan took silk in 2015 and has a renowned constitutional and administrative law practice. Before coming to the bar, he worked at the Office of General Counsel in the Commonwealth Attorney General's Department and later as counsel assisting the Solicitor General. Prior to these roles, Chris Horan was, relevantly to this evening's proceedings, an associate in the High Court of Australia to Justice Brennan. Chris Horan, welcome, and the floor is yours.
Thank you, and good evening, everyone. This is not the first occasion, and probably won't be the last, at which the legacy of Sir Gerard Brennan to public law has been assessed. Notably, as Justice Gageler has just mentioned, Sir Gerard's influential contribution to the field of administrative law was celebrated at a commemorative conference that was held at the Australian National University in November 1998, shortly after His Honour's retirement as Chief Justice of the High Court. Many of the papers delivered at that conference were later collected and published in a book edited by Robin Craik and Patrick Kaiser, another of the judge's former associates. The book included some additional papers, including one by Sir Gerard himself, examining then current issues in the review of Commonwealth administrative power. In this evening's seminar, it's impossible to cover Sir Gerard's contribution in anything like the same breadth or depth as has been done on such previous occasions. Perhaps one advantage that we now have is the perspective of several decades that have elapsed since His Honour's judicial retirement, so that we can more fully appreciate the indelible influence of his judgments and extrajudicial statements on the contemporary development of constitutional and administrative law. I acknowledge the insight and analysis in the paper given by Justice Gageler this evening, who has written and spoken about Sir Gerard's legacy in public law numerous times. I will endeavour to supplement Justice Gageler's observations by touching on a few particular facets of His Honour's lengthy professional engagement with public law. To fully appreciate Sir Gerard Brennan's contribution to the development of public law in Australia, it's necessary to start prior to his appointment to the High Court in 1981. By all accounts, Sir Gerard had a diverse and generalist practice at the Queensland Bar across the 1950s, 1960s and early 1970s. Of course, that period largely predates the modern concept of a specialist public law practitioner, at least outside of an academic context, and particularly at the bar. By the latter part of the 1960s, Sir Gerard was regularly appearing in cases before the High Court, particularly in appeals heard on the court's annual Brisbane circuit in May or between May and June each year. A perusal of the decisions reported in the Commonwealth Law Reports in which Sir Gerard appeared during this period reveals a broad range of subject matters, including companies and commercial law, restraint of trade, banking, local government, criminal law, negligence and personal injuries. There were also a handful of public law matters, including challenges to state laws based on Section 109 inconsistency or on Chapter 3 of the Constitution. Of course, to conduct such an exercise in relation to High Court matters alone is to examine only the tip of a very large iceberg. Other notable matters in which Sir Gerard was briefed during that period before his appointment as a judge include his appearance for the Northern Land Council in the Woodward Aboriginal Land Rights Commission in 1973 and 1974, an experience which might have informed His Honour's later deliberations in a succession of cases that came before the High Court throughout the 1980s involving land claims under the Aboriginal Land Rights Northern Territory Act 1976, and ultimately his landmark judgment on common law native title in Mabo No. 2. Some of these Land Rights Act cases raised issues of administrative law, the importance of which extended well beyond the immediate context of land rights. One notable example is Minister for Aboriginal Affairs and Pico Wallsend. Now, as is very well known, Sir Gerard was appointed in 1976 as the first president of the newly established Commonwealth Administrative Appeals Tribunal. The tribunal emerged from the recommendations of the Kerr Committee as a central component of what came to be described as the new administrative law at the federal level. As president, Sir Gerard played an important role in shaping the principles to be applied and the practices and procedures to be followed by the tribunal in performing its function of merits review. His immediate commitment to his new position was demonstrated by his relocation to live in Canberra, where he remained until his retirement from the High Court in 1998. To the best of my knowledge, he's still the only Justice of the High Court to have been based full-time in Canberra since the court moved to its new building there in 1980. Among the important matters settled by the tribunal in its early days under the helm of Sir Gerard was the adoption of what may be described as a judicial model of decision-making, under which the tribunal would stand outside and independent from the bureaucracy and the administrative machinery of government. That is, it would not be simply another tier of administrative review within the relevant department or agency. In one of the first cases to come before the tribunal, re Adams and Tax Agents Board, Sir Gerard confronted the question as to whether the tribunal could consider and determine constitutional questions, such as a challenge to the validity of a statutory provision, in the course of exercising its review powers. His Honour noted that an administrative body such as the tribunal could form an opinion on legal questions where this was necessary as a means for it to mould its conduct to accord with the law. However, as it did not exercise judicial power, the tribunal could not give a definitive answer or make a binding determination on such legal questions. Sir Gerard took the view that questions of constitutional validity stood in a more complex position, insofar as an administrative body could or should not override the will of the legislature in expressly conferring the relevant power or authority to decide. Accordingly, that was a matter that His Honour thought should be raised only before a court exercising the judicial power of the Commonwealth. In re Becker in 1977, a relatively early decision involving the now familiar situation of review of a deportation order, Sir Gerard declared that, quote, the legislature clearly intends that the tribunal, though exercising administrative power, should be constituted upon the judicial model, separate from and independent of the executive. The function of the tribunal was to decide appeals according to its opinion as to the merits of the case, having regard to, but not being bound by, the views of the primary decision maker. Among the issues that were identified as arising on such a review was a consideration of whether any applicable administrative policy was consistent with the governing legislation, and if so, whether there was any reason not to apply the policy either generally or in the particular case. Sir Gerard described this as a novel jurisdiction that would need to be worked out in the course of the tribunal's experience in future cases, but noted the different considerations that might arise in relation to different kinds of government and administrative policies. Justice Brennan revisited the role of government policy in merits review in his seminal decision in Drake No. 2, which also involved a review of a deportation order. In that case, the tribunal was required to consider the application of a policy statement that had been promulgated by the minister to guide the exercise of his deportation powers, a scenario that has now become a staple feature of administrative decision-making in this area. Sir Gerard laid down some important principles as to the practice to be followed by the tribunal in relation to ministerial and other government policies. These principles have since been treated as a definitive exposition of the role of policy before an independent merits review tribunal. Sir Gerard acknowledged the utility and desirability of such policy guidelines in promoting the interests of consistency in decision-making, observing that inconsistency is not merely inelegant, it brings the process of deciding into disrepute, suggesting an arbitrariness which is incompatible with commonly accepted notions of justice. Nevertheless, His Honour declared that the tribunal was free to depart from a guiding policy and even to adopt a different policy in the course of reaching the correct or preferable decision in the circumstances of the particular case. However, sensitive to the fact that such policies were often formed in a political context and involved interests going beyond the case at hand, Sir Gerard considered that the tribunal's approach should be cautious and sparing, and that there should be cogent reasons before the tribunal departed from a lawful administrative policy. The very fact that the tribunal was conceived to be apolitical and independent of the executive government made it inappropriate for the tribunal to embark on a review of broad policy beyond the facts and circumstances of the individual case. One situation in which there may be what His Honour described as cogent reasons to depart from a policy was in order to address an injustice in the particular case. As Sir Gerard put it, consistency is not preferable to justice. In this regard, Sir Gerard recognised that insofar as a policy invoked or relied upon the interests of the community, that was not exclusive of the interests of the individuals who were affected by the deportation order in the particular case. In effect, those interests of affected individuals were seen as forming part of the broader public interest. Sir Gerard noted that Australia's interests extend to an interest in them, for a nation's interests are involved when its government exercises coercive powers to affect individuals, and that Australia's interests are affected by the way in which the deportation power is exercised. Sir Gerard's reasons for decision in cases such as Drake No. 2 reveal an approach that is focused on the role of an independent tribunal in achieving administrative justice for individuals and corporations insofar as they're the subject of the relevant power, but with sensitivity to the proper role and accountability of the executive government for setting the broader policy considerations that should inform the exercise of administrative powers. These and other decisions encapsulate one particular aspect of the rule of law, in the sense of avoiding arbitrariness in the exercise of administrative powers and discretions, and ensuring rationality and consistency in administrative decision-making within legal limits. But they also demonstrate a keen awareness of the separation of powers and the respective roles and responsibilities of the legislative, executive, and judicial branches of government. These matters continued to inform Sir Gerard's judgments after his appointment to the High Court. Any evaluation of the judicial contribution of a particular justice on the High Court must come with a caveat. There is an inevitable tendency to focus on cases in which the justice delivered separate reasons, that is, either single concurrences or dissenting judgments. It's slightly more difficult to assess the contribution of a particular justice by reference to joint judgments or judgments of the court, whether as the anonymous author of the reasons for judgment or as a collaborator in the production of those reasons. Nevertheless, Sir Gerard did write separately in many cases during his tenure, which provides an opportunity to examine his individual legacy. In his speech on his swearing in as Chief Justice in April 1995, Sir Gerard reflected on the judicial oath to do justice according to law, noting that the jurisdiction of the court is fixed by law and judgment must be rendered in accordance with the judicial method. That judicial method, Sir Gerard explained, starts with an understanding of the existing rules. It seeks to perceive the principle that underlies them, and at an even deeper level, the values that underlie the principle. Thus, in Sir Gerard's exposition of the judicial method, the legal rules that courts are constrained to apply are placed within a framework of principle and in turn give expression to more fundamental and enduring values. In the field of public law, some of the values that inhere in Justice Brennan's judgment in the High Court are the rule of law, the separation of powers, and the dignity of the individual. His approach to public law reflected an appreciation of the proper relationship between the respective branches of government. As Justice Gageler has noted in his paper, Sir Gerard's judgments in cases such as Woodward and Quinn stressed the nature and limits of the court's role on judicial review. That is, the function of the judiciary is to declare and enforce the law, both as to the extent of the power and the legal limits on its exercise. The passage from His Honour's judgment in Quinn, which drew upon and elaborated the fundamental precept derived from Marbury and Madison, fixed a clear demarcation between issues of legality on the one hand and the merits of an administrative decision on the other. The Court on Judicial Review is not concerned to correct administrative injustice or error, other than as incidental to its constitutional role of enforcing the legal limits on the extent or the exercise of a statutory power. While these propositions have since become almost trite, Justice Brennan's judgment in Quinn remains highly influential and is still frequently cited and applied in contemporary contexts, including in recent decisions by the current High Court. And one example I would refer to is the recent decision in MZ-APC, in which each of the judgments cites and relies upon that particular passage quite heavily. Justice Brennan's judgment in Quinn gives expression to another central conception of the rule of law in the strict sense, in terms of the subjection of the executive government and its officers to the laws of the land, including in particular the valid enactments of the legislature. This approach aligns with an ultra vires theory of judicial review, whereby the limits on administrative powers are derived principally from express and implied statutory conditions. On that theory, the court's function can be legitimised and justified as the enforcement of the intention of the Parliament, rather than being sourced in or derived entirely from the common law. As Justice Brennan stressed in his judgment in Annetts and McCann, the only sound foundation for judicial review is, in my view, the statute which creates and confers the power, construed to include any terms supplied by the common law. Such a rationale has since become more or less accepted for judicial review of statutory powers on grounds of procedural fairness and legal unreasonableness. However, the position of non-statutory executive powers remains for consideration. In this regard, Justice Brennan also left us with an influential analysis of the different aspects of executive power. In Davis and the Commonwealth, a case decided in 1998, involving a constitutional challenge to Commonwealth legislation in relation to the bicentennial celebrations, issues were raised about the content of the executive power of the Commonwealth conferred by Section 61 of the Constitution. In that context, Justice Brennan embarked on an examination of the different aspects of the power of the Commonwealth Executive to engage in enterprises or activities without statutory authority. His tripartite classification covered statutory powers or capacities, prerogative powers or capacities, in the sense of rights or powers enjoyed by the Crown alone, rather than in common with its subjects, and capacities which are neither statutory nor prerogative in nature. This exposition of executive power has been repeatedly drawn upon in subsequent cases, including recently by Justice Gageler in his judgment in Plaintiff M68 of 2015. It is likely to attract ongoing attention in cases yet to be argued before the High Court involving the judicial review of non-statutory executive actions. Time does not permit a more extensive examination of Sir Gerard's influence and contribution across a number of other areas of constitutional and administrative law, including the implied constitutional freedom of political communication, federalism, the development of the law of procedural fairness, to name but a few. It remains for me to conclude perhaps on a slightly more personal note. Anyone who worked with or appeared before Justice Brennan would have found him to be a wise, patient and deeply thoughtful lawyer with a comprehensive understanding of legal principles. He had an almost instinctive feel for the application and development of legal rules. While I was working as his associate, I recall an occasion where the judge was writing a judgment in which one of the points turned on the application of a judgment in an earlier case to which he had been a party. I can't now remember the precise details of the particular case, but it turned out that the outcome illustrated and fell within a qualification that had been expressed by His Honour some years beforehand in an earlier judgment. As I recall it, the judge remarked within his chambers, almost with surprise, about the prescient manner in which the principles in the previous judgment had been formulated, unconsciously anticipating their application to unknown future circumstances. This is a testament both to Sir Gerard's jurisprudential foundations and to his judicial methodology. He remained throughout a person who was generous and gregarious, with an inclusive and often jovial disposition. His legacy is sure to be long-lasting. Thank you very much.
Thank you, Chris Horan, for your wonderful words. As Chris said, in his talk just then, there will be surely more tributes than this evening to Sir Gerard Brennan, and rightly so, but the warmth and humility and sincerity and respect and sheer appreciation conveyed in both of the tributes tonight, I think will be memorable in itself. So if I could just thank again Justice Stephen Gageler and Chris Horan QC for sharing those thoughts and those deeply held tributes with us this evening. That brings our webinar to a conclusion tonight. It is, as I said at the beginning, part of the CCCS Global Seminar Series. So if you're not already on the CCCS mailing list to be alerted to any events like this, please get in touch with us. But once again, thanks to our panellists and for the special occasion of honouring the legacy of Sir Gerard Brennan to Australian public law. Good evening.